second part of the morning. We will start with Professor Rosie Harvey, Chair in Law and Society at the University of Birmingham, and she's gonna present around saying yes, saying no, consent and refusal in decision making about medical treatment. So please, Professor Harvey.
I know Rosie's much better than Professor Harvey, I'm sure. Okay, so the usual faffing around with PowerPoint to get it to do what we want it to do. Thank you very much to Eleanor and Tina and the Voices people and Liz for inviting me to come and talk to you again. Last time I was here in Ireland talking about consent to medical treatment, it was at your launch conference. I had a grand total of 10 minutes to outline the law on consent to medical treatment, which was a challenge, one could say. So thankfully they've given me a little bit more time today, and I'll try not to go on and on and on and on about it. But I could probably talk for most of the day about different aspects of the law relating to consent to medical treatment. But instead of doing that, I'm going to start off with the general rule about consent, which you've already heard, but it's worth reiterating regularly. I'm going to talk about legal frameworks which create exceptions to that general rule, just to give an outline of the legal context in which I'm talking. And then I'm going to go into a little bit more detail about both consent to treatment and refusals to treatment, by giving you some detail about two recent English law cases. Well, actually, Montgomery and Ladders is a Scots law case, but the principles that apply in it apply across both England and Scotland. Obviously not relevant specifically in Ireland at this time, but likely, I think, to be relatively persuasive at different points. And my aim in using these two cases is to try and talk a little bit more about how things have changed in the English legal context since the CRPD without actually us having a change in legislation. The Mental Capacity Act in England came into force in 2007, which was after the CRPD, but the legislation was passed in 2005 before the CRPD, and it has, as I'll say, it has a functional text. It's not entirely CRPD compliant. But things are changing. I want to talk a little bit about how things have changed in England, why things have changed in England in the last couple of years, and what it is that we can do to continue to change things, even in the face of political refusal to change statutory contexts. Okay, so the general rule: medical treatment can only be given when the patient consents to it. Medical treatment without consent is either battery in the civil law or assault in the criminal law. That's the general rule. To give medical treatment, we need to have consent. Unfortunately, we do have some legal frameworks still which allow medical treatment without consent. These are generally termed as mental health laws and mental capacity laws. And you heard quite a bit already about mental health laws this morning, and I'm not going to go into a lot of detail about them, primarily because mental health laws specifically are not really in my area, so you're much better off speaking to Tina about those, or Piers, who's much better on mental health laws than me. I'm more of a capacity type person myself. So these are the relevant mental health laws in England, Wales, Ireland and Scotland at the moment. I hope I've got the Irish law right. I think that's really very much about it. The Scots law is the most recent of these. The English law was amended in 2007 but didn't take away compulsory treatment. All of these legislative frameworks allow for compulsory treatment in mental health contexts. There are various different procedural safeguards that are put in place when people are compulsorily treated under these legislative frames. But the fact remains that they all legally facilitate compulsory treatment of people with a diagnosis of some kind of mental health disorder. Similarly, we have mental capacity laws. I know that the Irish law will not in force. Do we know when it will be? Okay, says Eleanor. So that'll be a no, we don't know yet. It's very similar to the English Mental Capacity Act, which in lots of ways is very similar to the Adults with Incapacity Scotland Act. And all of these rely to greater or lesser extent on the functional assessment of mental capacity. If a person is deemed to be unable to use and weigh the relevant information about a decision and then come to a decision and communicate their decision, they are determined to lack the capacity in one way or another to make that decision. That's what our mental capacity laws do. So, why then do we have this idea of consent in law? Talks about the exceptions, now I'm going to talk more about consent and refusal, as I said I would. Consent has a variety of legal purposes. We've heard about the fact that we have a right to consent, but why do we have a right to consent? Well, first of all, it offers protection under the law to medical practitioners from charges of assault under the criminal law or battery under the civil law. So retorted battery or the crime of assault. We have consent requirements in order to say this doctor treated that person with consent, because any intentional touching that does not have consent is an assault or a battery, depending on the particular civil or criminal context that we're talking about. The concept of consent also has the purpose of protecting patients' rights to autonomy and to bodily integrity, which we've touched on a little bit this morning already. And it ensures that patients are informed of material risks associated with the treatment that they are given. So consent is a protective framework both for doctors and for patients. And I'm going to talk a little bit more about each of the terms that I've put in italics here on this slide. So first of all, autonomy. Autonomy is protected under the CRPD explicitly. Let me just find my notes. I wanted to get that special gadget up there where you see your notes on this screen while they're not up on that, but it's beyond my technological capability. So instead I'll just have to hold a heavy laptop in order to do this. So, autonomy is protected under Article 3 of the CRPD, and I quote, it's the first of the principles under the Convention. So, the principles of the present Convention shall be A, respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons. Now, conceptually speaking, autonomy is difficult. It's something that has exercised philosophers, jurisprudence, legal theorists, and others for many, many centuries. It's not an easy concept. We can put an easy definition into it, the right to make our own choices. That's straightforward. But what does that actually mean? What's the content that comes up in making our own choices? Is my own choice the choice that's right for me as an individual, or is it the choice that's right for me within my relational context? Me and my partner and our daughter and my community, in my work context. Are the choices that I make purely about me, or are they about me in my relational context? And there's a big debate around whether autonomy should be understood in a legal sense, in a sort of liberal, individualistic way, or as a relational understanding of autonomy. That when we make decisions, we do make them within the relationships that we exist within. I'm probably more on the relational side of that equation, but I don't want to go into a great deal of depth on that today. I have a book coming out later this year about dementia care and dementia care contexts, where I go into depth on that issue. It will be published in May or June, so ask me then and I'm going to talk about it more, or share bits of it with you. But I didn't want to labour that point today, but just to say that autonomy doesn't always mean making a self-interested decision. It doesn't always mean making a decision that's only about ourselves, and it doesn't always mean getting our own way. So having a right to autonomy doesn't always mean saying that what you want to happen will be the thing that happens. We don't have a right to demand a particular form of healthcare treatment. We have a right not to be given healthcare treatment that we don't want, but not to demand a particular type of healthcare treatment instead. So that's autonomy. Difficult concept, simple idea. That makes sense. The second concept that I highlighted on my previous slide was the idea of bodily integrity. Now, bodily integrity is also protected explicitly by the CRPD in an article that's I don't think we mentioned yet today, Article 17, which says every person with disabilities has a right to respect for his or her physical and mental integrity on an equal basis with others. Bodily Bodily integrity means that you get to decide what happens to your body. I get to decide what happens to my body. I can't decide what happens to your body. You can't decide what happens to my body. My body is my body, your body is your body, and they are separate, distinct, physical entities. And we have a right to decide what happens to them. And when medical treatment is given to a person without consent, or where their consent is not fully and freely given, then this is an interference with that person's bodily integrity. One area where consent gets a little bit more challenging is where consent is given when a person hasn't been told of the material risks that are associated with the treatment that they're about to be given. We heard some stories about that earlier this morning from Fiona and also from Satwa as well. Now, the second quote on this slide here is from the first case I'm going to talk about, the Montgomery case. And here, the Supreme Court in England and Wales, Scotland, said an adult person of sound mind is entitled to decide which, if any, of the available forms of treatment to undergo, and her consent must be obtained before treatment interfering with her bodily integrity is undertaken. So that is the general principle. Now, we might want to challenge this idea of sound mind in this particular equation, and this particular quote. This particular case was not one which involved mental health. It didn't involve psychosocial disability, and it didn't involve intellectual disability. But the principles, the general rules, I think apply to everyone. We might want to delete sound mind from that quote, and I was quite tempted to do so when I was reproducing it, but then that wouldn't be very fair on the Supreme Court justices. Okay, so material risks. What do we mean by material risks? Well, how much information should a patient be given about the risks inherent in medical treatment in order to give consent? And what duties do doctors owe about providing that information about risks? Now, I'm going over ground which Tina did touch on earlier this morning, but I think it's worth going over this ground within the UK context as well as the US context, because ideas of informed consent are different in England and Wales, in Scotland, in Ireland than they are in the US. The US philosophical tradition is built up on a particular understanding of informed consent, and that's not quite the same as the way it's developed in the English legal system. Now, so the first case I want to talk to you about is Montgomery and Lanarkshire Health Board case. This was a medical negligence case, medical negligence about the duty to advise on risks related to pregnancy and birth. Back to my big heavy computer for the bit that I didn't print out. Nadine Montgomery won £5 million of compensation from the UK Supreme Court in 2015 in a landmark case which shifted legal approaches to medical consent in UK law. As a UK Supreme Court decision, of course, it has no persuasive force here in Ireland, but it may well be influential in different ways as time goes on. Mrs. Montgomery sued the hospital where she gave birth to her son Sam, pictured here with her, in 1999 after complications during his birth as a consequence of shoulder dystocia. I may not be pronouncing that right, I don't know. Miss Montgomery, as you can see from the picture there, is quite small. She also has type 1 diabetes. Babies born to diabetic mothers are often larger than average, and that was the case with Mrs. Montgomery's son Sam. Mrs. Montgomery's doctor did not tell her of the risks of shoulder dystocia associated with vaginal delivery, nor did the doctor tell her of the risks to the baby associated with shoulder dystocia. There was a 9 to 10% risk that shoulder dystocia would happen, and there was a 0.2% risk that the baby would have a brachial plexus injury right here, which entrapped the spinal cord and caused paralysis down one arm, and there was a 0.1% risk, so a 1 in 1,000% risk, 1 in 1,000 risk of the umbilical cord becoming trapped during birth, causing hypoxia, starvation of oxygen to the brain, and potentially causing cerebral palsy or death. You can see from the picture that Sam didn't die. Unfortunately, during birth, which was not very straightforward, shall we say, Sam's shoulder did become trapped, and he suffered cerebral palsy, which affects all of his limbs, and palsy to one of his arms. The doctor in question didn't tell Mrs. Montgomery of the risks associated with vaginal delivery, even though she'd expressed a concern about her ability to perform a vaginal delivery of her baby. Even though she'd asked questions about it, the doctor decided that it wasn't in her best interests to know about these risks. I could go into more detail about it. I have reproduced on my slide here all of the way that the birth is described in the case, but I think for all of our sakes, I'll just keep going, especially move on. The Montgomery case. Mrs. Montgomery lost her case in Scotland. She lost in the outer house, she lost in the inner house. She lost her appeal, she took it to the Supreme Court. The earlier courts were following a line of authority which said it basically up to the doctor how much risk they had to disclose and what risks they had to disclose. What we got when we got to the Supreme Court was a collegiate decision of 7 justices of the Supreme Court. This is a strong decision. So 6 of the judges gave a collegiate decision, a decision that they came up with together, and then there was a little footnote about pregnancy and birth added by our only female judge in the court of Supreme Court, Lady Hale. But she said explicitly, I agree with all of them as well. So this is a strong Supreme Court precedent that's been set. And what they said was that consent to medical treatment requires knowledge of the material risks. You cannot consent to medical treatment if you have not been told of the risks that are associated with it. And doctors have a duty to discuss those risks with patients. And patients are now widely regarded as persons holding rights rather than as the passive recipients of the care of the medical profession. So this is a big shift in English law, and it hasn't come from statutory reform. It's come from a change in the common law. The justices said, and I quote, the idea that patients were medically uninformed and incapable of understanding medical matters was always a questionable generalisation. To make it the default assumption on which the law is to be based is now manifestly untenable. So this is strong dicta from our Supreme Court about the necessity of taking a rights-based approach to patient care and also to disclosing the material risks associated with treatment. Interestingly, in this part of the decision, which I think reflects some of the discourse that we had earlier again, the justices were talking about the greater availability of information about treatment choices that patients have access to now that they didn't necessarily have in the 1980s when the previous precedent was set away. So the internet is more available to people. There's lots of information on the internet about drugs and about side effects, about procedures, about what happens, about the potential things that can go wrong. And secondly, there's more information in drugs, patient information leaflets set out the side effects that are potentially going to happen to people. So there's much more information available, and this judgment is a judgment about disclosure and discussion of the material risks in the information age. So now that more information is available to people, doctors have to discuss it more with their patients. Scots law. The justices went on to say that the doctor is therefore under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or varying treatments. The test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would attach significance to it. There's 2 parts of that test, and this is interesting to me. I need to go into a bit more depth on this that I don't have time for today because I've got less than 10 minutes left. Don't know how that happened. There's an objective test, a legal objective test, the reasonable person of law. But there's also a particular patient test, a subjective test. So it's the insertion of the subjective, of the individual voice into medical treatment law that's coming through in this Supreme Court decision that I think is hugely significant and I think is as a result of the changing discourse that's happened in English mental health law, in English mental capacity law, since the CRPD. So I think this decision is as a result of, even though it's not mentioned in the judgment, I think it's a consequence of the CRPD and of the changing international soft law legal context that comes up through it. I can't prove that, but I can argue. They went on to say that the doctor's advisory role in this situation requires them to enter into a dialogue with the patient about what the risks are, and to give the information in a way that's understandable to patients and in a way that the patient wants to receive it. So that's another good thing that's come out of this judgment. And finally they said of this thing called the therapeutic exception, which was very strong in Sidaway, the previous authority. In Sidaway, it was said by Lord Templeman, and I quote, "The provision of too much information may prejudice the attainment of the objective of restoring the patient's health." So in the 1980s, it was thought that if you gave the patient too much information about what might go on, or what they might experience in treatment, that would be bad for them and might stop them from getting better. That has been squashed by this decision. It's not gone completely. Maybe we wish it should have been, but this is a place where we can do more legal activism around that. But they said it's important that the therapeutic exemption should not be abused. It is limited, and it's not intended to subvert the principle of consent to medical treatment. So paragraph 91 in the judgment. So I think this case in general, and in the dicta specifically, represents a positive move in understandings of consent to medical treatment in English law towards a much more patient-centric approach, even though these developments have come through changes in the standard of care in clinical negligence. So we have to look at cases like this, even though they're not statutory reforms around mental health or mental capacity law. So I'm going to move on then to now to think my last few minutes around refusal of treatment and what happens when people say no. Because actually, when a patient decides to say no to treatment, that's when they tend to be held to a higher standard. Now, we don't have a risk-relative understanding of consent in English law, and yet, this is what happens. When somebody goes along with treatment, it's fine, you've got the capacity to consent, we're not going to challenge that. When somebody says, actually, no, I'm not going to, I don't want this, that's when the law comes in, when there is elements of coercion of trying to get people to do things that they don't necessarily want to do. I'm going to talk about refusal in three senses, and probably the last two senses are going to be very compressed because I want to give a goodly amount of time, with what I have left, to talking about contemporaneous refusal. Now, we've already heard today that Article 12 of the CRPD requires that state parties recognise persons with disabilities, intellectual disabilities, psychosocial disabilities, as well as physical disabilities, enjoy legal capacity on an equal basis with others in all aspects of life. And I've highlighted enjoy because I think that's the most important word in Article 12. It's not just that we recognise people with disabilities as legal persons. It's not just that they are persons in law, as some might argue, but it's to enjoy legal capacity, to hold it and to use it. Enjoy has both elements. Previously, we've also heard about general comment number 1, which requires that practices that in purpose or effect violate Article 12 must be abolished in order to ensure that full legal capacity is restored to persons with disabilities on an equal basis with others. So, the second case that I want to share with you today is a case called Wye Valley NHS Trust and Mr. B. Now, this was a case of the Court of Protection in England, and it was heard by this judge here, Mr. Justice Peter Jackson. Mr. Justice Peter Jackson's in the news quite recently as being the first judge in English law to use emojis for judgment. That's quite interesting. It was a very accessible judgment aimed at young children so they could understand what was going on, and he used emojis in it to help to convey his point. He's one of the good guys. Anyway, in the Wye Valley NHS Trust, this was a case about Mr. B, who was a 73-year-old man who was refusing the amputation of a severely infected leg. I will read out to you what the judgment says about the facts of Mr. B. Mr. B was an only child whose parents died when he was in his 20s. He had a number of relationships with women that did not last, and he describes occasions when he fell foul of the law as a young man. In his mid-20s, he developed paranoid schizophrenia. He has been treated with antipsychotic medication, generally with sufficient success to allow him to live in the community, though his medical notes running back to 1994 describe over 10 compulsory admissions for treatment since then. He has only been fit to work briefly. He has for many years experienced persistent auditory hallucinations in which he hears voices of angels and of the Virgin Mary. He told me that they had stopped him from thieving. He told me that he did not consider himself to belong to any particular religion, saying, "I'm not fussy," but he explained that Mary wants him to be a Catholic. He had a 20-year relationship with a woman also suffering from mental illness who died in 2000. For some years, Mr. B has suffered from type 2 diabetes. His compliance with medication is at best patchy, and the diabetes is not well controlled. About 12 to 18 months ago, Mr. B developed a chronic foot ulcer that has not healed despite various interventions. In July 2014, he was admitted to hospital. Amputation was discussed, but in the event, the ulcer was debrided and insulin treatment was restarted. In August 2014, he was transferred to another hospital. In December 2014, he went to another hospital. In January 15, he transferred as an informal patient to a psychiatric hospital because his psychotic illness had relapsed. This led to a further transfer in March 2015 for continued psychiatric treatment. So it's a joint kind of psychiatric and physical health treatment issue going on here. For whatever reason, the judgment goes on to say the treatment given to Mr. B for his mental illness during 2015 was not a success, and he was then compulsorily admitted. Nevertheless, he continued to resist medication for his diabetes and antibiotics for his foot, with the consequence that by the time his mental health had begun to recover in August, his physical health had markedly deteriorated. He was becoming tired and lethargic, and the infection was becoming systemic. His foot was not only infected, but putrefying, and the bone itself had become infected. He was refusing all treatment, but allowed his dressings to be changed. Mr. B didn't want his foot to be amputated. He would rather die than have his foot amputated and lose what independence he had remaining. He was 73 years old. He was ready to face death. Mr. B was found in the judgment to lack capacity to refuse the treatment on account of his mental disorder. He wasn't using and weighing the information in the ways that a functional test would require. He was listening to the voices inside him and using those to guide his decision. But he expressed a clear and consistent desire in the strongest possible terms in opposition to the amputation, and the court made a best interest decision to respect Mr. B's wishes and preferences. So what's happened in this case is that instead of the medical profession saying this man is delusional, he doesn't know what's going to happen to him, we're going to listen to him, we're not going to force him to have his foot amputated, and we're going to continue with the treatment there. So, this is what the judge said. I am quite sure it would not be in Mr. B's best interest to take away his little remaining independence and dignity in order to replace it with a future for which he understandably has no appetite, and which could only be achieved after a traumatic and uncertain struggle that he and no one else would have to endure. There is a difference between fighting on someone's behalf and just fighting them. Enforcing treatment in this case would surely be the latter. Why? Why did Wye Valley happen? Well, there's been a range of different changes building on one another since the Mental Capacity Act, since the CRPD, that have created the situation that this case could occur. First of all, we had the decision in Atria University Hospital's NHS Trust and Jails from 2014, another Supreme Court decision, at this time the lead judgment from Lady Hale, where she said that the purpose of the best interests test is to consider matters from the patient's point of view. Now, it took about 18 months for that to filter through the ways that the Court of Protection have been using best interests in the English law context. But actually, instead of an objective best interests approach in England, what we seem to be getting now is a subjective patient point of view, patient's wishes and feelings focus in capacity law, which I think is very, very interesting. CRPD Article 12 and the general comment, I think, must have shaped this. It has to have had an impact on what's going on. You know, these things don't happen in isolation. Our Supreme Court justices know what's going on in the world and the world of law. They listen to the things that are going on. Justice Peter Jackson listened to the voice of Mr. B in this case, even if the law technically refused his capacity. And I think that I'm going to skip over that one, and I'm going to skip over that one for a moment. That it's the voices of people with intellectual and psychosocial disabilities that are now being heard by law in a way that they weren't previously. And this has partly come about because of changes to the Court of Protection rules that came in 2015. So about 3 months before the Mr. B case, the Court of Protection rules changed to ensure that P, the person who the proceedings were about, was involved in any proceedings relating to them wherever it's possible to do so. So in this case, there was a hearing on the 24th of September. Mr. B wasn't there. The next day, the judge went to the hospital where Mr. B was and had a lengthy conversation with him, and then refused the order that had been applied for by the judge. So it was because of listening to the voice of the person with intellectual or psychosocial disabilities that the law was able to recognise and put into that context. Now, I'm not disputing that the Mental Capacity Act probably needs to be changed. I'm not disputing that we need to get away from a functional interpretation, but in the meantime, there are things that are changing, and they're changing because of the activism of people like you all. They're changing because people's voices are being heard by the legal system in ways that they perhaps weren't previously. And I think that it's important to bear that in mind, that all of this can have an impact, it can have an effect, and you can see it, you can trace it through the ways that judges are speaking about intellectual disability and psychosocial disability in the context of consent and refusal to medical treatment. And if anyone wants to know more about the bits that I skipped over, ask me the question. Thank you very much.
Thank you very much, Rosie. We will have time for questions after the 2 more presentations. We have now our third pair. They are both from Australia. We have Cath Roper, a consumer academic from the Centre for Psychiatry and Nursing of the University of Melbourne, and responding, Piers Gooding, who is a postdoctoral research fellow also at the University of Melbourne. So please, Cath.
Thank you. So what we're going to do is I'll start with a story or a non-story, and then Piers will follow, and if there's time after that, maybe just some further comments. So I'm going to have to do that a bit. Okay, so there are many reasons to shy away from telling stories. Or what if the tellings evoke pity or disengagement or incomprehension, or the contents seem trivial to hearers? Thank you. So this isn't a story. This is attempts to explain things against a backdrop of realising that understanding is very far away and will always be incomplete. But there is urgency in seeking language. Each possible word can both liberate and contain, but they never quite fit. The fitting attempt frustrates. When the languaging of experience, trying to find words, has no ready frame out there, the task is difficult and intense. And when the speaker is mad and what she tries to say, what she sees, is not to be trusted, and she might suddenly lose the plot. So yeah, I've suddenly lost the plot. I've just gone right to the end without wanting to. Pardon me. You would be on the edge of your seat for discomfort if I suddenly lose the plot. I've been repeatedly rendered a non-person through legal means, an unmade person whose decisions are not to be respected, a person whose thinking is faulty, whose imagination is disliked or found to be ill-fitting. The surrounding emotions of this are cavernous, hungry, lonely, wordless, embodied, raw, unprocessed experience. The body and emotion are source, and the distance between source and understanding is vast. Sense-making, the acquisition of concepts, the choice of words, attempts at communication are faltering. I never experienced hospitalisation or treatment as a beneficent act because everything that happened was against my expressed will and delivered violently without permission into my body. Over a 13-year period of my life, I'd been voluntarily detained each year around winter time, usually for about 6 weeks, back in the days of large institutions. So if I press this, we'll go to the next. Yes, large institutions. The purpose of detention was to ensure psychiatric treatment. Being repeatedly subject to these experiences taught me that my body was not my own. My body had no integrity. It was no longer whole, and I was assailable. And what were the consequences of this? Under the surface always are varying degrees of outrage, bewilderment, like bruises. How could the state force itself onto my body with impunity, telling me the violence is for my own good and for my health? There is a cupboard I can usually choose to open or close. Within its darkest recesses are partial memories spanning those 13 years, some drugged memories, faintly strobing, foggy and dimly lit, many sharper incidents like short films, some on repeat like broken technology, some echoes, moments, experiences or shameful, violent, cellular shocks that ambush me when I'm not expecting. It isn't the obvious violence and dehumanisation, though, that concerns me now, all these years later. The sexual assault at the hands of a charge nurse, or being cuffed by police and bruises showing up the next day from rolling around in the back of the divvy van. Actually, in that occasion, I had a nightgown on and it kept on opening because they wouldn't let me change before sticking me in the divvy van. Arriving at the hospital, the numerous instances of being dragged into seclusion, held face down, pants removed, being injected, or watching a nurse throw a girl against a wall, or physically being picked up myself and thrown into my room at night when I was supposed to be asleep, or having a red-faced, apoplectic male nurse scream in my face as she swallowed them about the tablets I've been forced to take. What concerns me now is trying to characterise the abusive, violent relationship the state began with me, to fathom how the community I live in could collude, saying it's the best thing for me, to shun me this way and condone the violence and agree it was for the best. How do I find belonging then? Law and medicine joined forces to enter my body, mind, spirit, overriding my will, my refusals. Like all good colonial forces, they would combine and take language from me, thieve meaning away, and re-present it in unrecognisable forms. Self becomes alienated from itself. Life becomes parted from liver. Sick, insightless, wrong, non-person who cannot know her own mind. The more I would resist the medical help and its explanations, the more violent the manner, the administration of unwanted treatments became. More seclusions, more injections, more time in high dependency, not allowed visitors. I want to just share a quote with you that is originally written about people's experiences in concentration camps, and I don't want to suggest that the experiences of involuntary treatment are the same, but I want to explore this concept that's arisen out of writing around this called ethical loneliness, and that's not it. That's it. Ethical loneliness is the isolation one feels when one, as a violated person or as one member of a persecuted group, has been abandoned by humanity or by those who have power over one's life possibilities. It's a condition undergone by persons who have been unjustly treated and dehumanised by human beings and political structures, who emerge from that injustice only to find that the surrounding world will not listen to or cannot properly hear their testimony. These claims about what they suffered and about what is now owed them on their own terms. So Ethical loneliness is the experience of having been abandoned by humanity, compounded by the experience of not being heard. Such loneliness is so named because it is a form of abandonment that can be imposed only by multiple ethical lapses on the part of human beings residing in the surrounding world. So I always thought that I'd kept a kernel of myself away from the clutches of psychiatry. I was quite proud of that. But one day I found a letter I'd written to someone I shared a house with, and she was overseas. And for some reason I'd kept a copy of it. And it showed me that I did believe I had been colonised. And in the letter I was apologising really profusely in this really obsequious way for my bad behaviour, for treating, for being mad, basically. And I was very ashamed of myself in this letter. And when I read it, it dawned on me, yes, I had been colonised. Because I think we learn to surveil ourselves in the same way as we have been monitored. It's a funny relationship to have with the self. But the letter also demonstrated the distance I'd travelled from having adopted those psychiatric explanations that seemed to shrink life down, to dehydrate it, back to inhabiting a mysterious and creative universe where anything is possible. So there was a distance between the time of writing that letter and the time of finding that letter. And so I just wanted to have one comment, and then I'll hand over to Piers. We are giving medicine the keys to defining and classifying and treating sick minds, and this is backed by legal provisions that are designed to ensure that psychiatric treatment can be given against people's will. So of course the giving of this treatment in this context will involve physical violence on the part of people, on the part of providers, onto people's bodies. This is inescapable. But the violence won't be seen for what it is. It'll be presented as a kindness. It'll be redescribed as necessary treatment for a person's health. And this is, of course, mad-making for the recipient. It creates, I'm arguing, it creates ethical loneliness. So I want to hand over to Piers now with the question of how can we use law to help with this?
Thanks, Cath. Can everyone hear me okay? I'm going to try and grope through the fog of jet lag and speak coherently and try to build on what Cath has said and shared by discussing some concepts and linking those concepts to the CRPD. And some of these concepts were really given to me or shared with me by Cath, and we started talking about concepts, and only in the last month I heard some of Cath's stories, so to speak, about what happened. And I'm sure it's shared here in the room that what those stories contain is poignant and distressing and part of a rigorous search for new social knowledge to try to deal with the issues that we're discussing here. And for me, an overwhelming response in reading and hearing about those experiences was, how can the law guarantee that this never happens to a person? Or where the law might not be able to guarantee much, how can we prevent the law from sanctioning these kinds of actions and instead to form part of a more humane response to distress and disablement and madness, to use Cath's terms. So the law that was activated in those years that Cath mentioned was the Mental Health Act of 1986 in Victoria, and this act was presented as a very progressive, rights-based act, and its aim was, in the words contained in the principles, to treat people in the least possible restrictive environment and least possible intrusive manner consistent with the effective giving of that care and treatment. Now, I think I'll leave it to you to sort of think about the difference between those words and what Cath has described. Interestingly, the Human Rights and Equal Opportunity Commission in Australia argued 6 years later that the Act was marked by circularity of reasoning and apparently designed to intrude to a minimal degree upon the territory of psychiatrists. I don't want to focus solely on psychiatrists because there are clearly public officials, nurses, police and others, bystanders implicated in what's going on here. But if there's minimal intrusion on the territory of psychiatrists, what does that do to the territory of service users or people with psychosocial disabilities? And what are some of the ways we can unpack this further to try to identify the possible flow-on effects of this unequal treatment? And how can those flow-on effects inform the search for alternatives? So the term epistemic injustice was coined by Miranda Fricker and shared with me by Cath to describe two forms of injustice which I think are useful here, and they consist in a wrong done to someone specifically in their capacity as a knower. She describes testimonial injustice on the one hand and hermeneutical injustice on the other. And testimonial injustice is caused when prejudice causes a hearer to dismiss or give a deflated level of credibility to a speaker's word. And hermeneutical injustice occurs at a prior stage when a gap in collective interpretive resources puts someone at an unfair disadvantage when it comes to making sense of their social experiences. So an example would be if you are black and the police do not believe you because of that. Or an example of the second type of epistemic injustice is that you might suffer sexual harassment in a culture that still lacks that critical concept. So you don't even have the words. So again, we're referring to being so discredited that you're not taken seriously on the one hand, and the social framework being so oppressive that there aren't even words to describe how that can happen. Cath described where her will and preferences were pathologised and disregarded and rendered irrelevant through law. And hermeneutical injustice is by its nature harder to define. And over the years, having read much of her work, Cath has accumulated concepts to describe injustice. But this doesn't stop the fact that the broader culture might lack critical ideas for receiving them or even to comprehend them. And the fact that these interventions might be wrong. And Tina yesterday made the point that concepts may exist. They may exist in sort of underground ways or amongst activists or those who are marginalised, but those concepts and ways of knowing might be disregarded or they might be actively ignored. So there are some links to torture and cruel, inhuman and degrading treatment here, which is a point Alberto made yesterday in our discussions too. I don't have time to go into it, but torture is an extreme act of aggression, but any act of dominance that's intended to bring about submission of another person is inherently aggressive, no matter how minor the act is. And it's amazing to hear today in the stories the strategic negotiation that service users and people with disabilities have to make to try to essentially play the game and elicit the answers that they want and, give the answers that they think the listener wants in order to get through it. But the burden of a lifetime of both overt and subtle aggressions, I think as we've heard, but is also well established in psychological literature, flattens confidences, causes distress and diminishes health. And oppressed individuals quite reasonably seek to dilute, postpone or deflect these kinds of small-scale aggressions or large-scale aggressions, similar to the response of a torture victim. And the dynamic to control the victim is the same. So I don't know if I'm going too far there, but they're just some observations that I didn't make actually about those aggressions, but I've heard a psychiatrist named Dr. John Rayleigh make actually. And ethical loneliness. If we're to harness invisible or marginalised stories to push for change, the first step is to make them visible, to bring them to the centre, which I suppose is what this project is about. And naming ethical loneliness, as Cath does, is an inevitable step or a necessary step in this process. And we might build on this idea to describe legal loneliness, because if you think about it, or Theresia Dejeuner has made this point, when international human rights law was first developed, people with disabilities weren't included as a protected category. You would see gender and race in all of the International Bill of Human Rights, the three instruments, but not disability. And this is particularly prominent in the mental health context. Lots of, you all know the institutional abuses and experimentation, but even in the years that Cath describes in 1988 to 1990, there was a Royal Commission in Australia underway about Chelmsford deep sleep therapy, where 24 patients were killed directly as a result of these treatments. And it's not to say that state and professional interventions have failed at every turn, because there are stories of success in humanity that are well documented. And I also think that in thousands of communities, there have been exquisite responses to distress and madness that haven't used coercion, which aren't necessarily documented. So I think drawing from those community responses is something that's very undervalued. But it's also true that when abusive and prejudicial practices did occur, the most systematic and large scale of them nearly always occurred with the law. Certainly none of the doctors involved in the deep sleep therapy were convicted, for example, in that one example. And it's worth remembering that in Nazi Germany, people with intellectual disabilities and psychosocial disabilities were the first to be murdered in concentration camps and the last to be officially commemorated. So I think there's a legal loneliness that goes along with that. And what has happened in modernity, that liberal principles were suspended for people in mental health crises, those with intellectual disabilities, or those imputed to be mad. The CRPD has essentially put an end to this legal loneliness, and I think we've heard about some of the ways that it's starting to affect this in practical ways, in laws, in courts, in services and so on. It's very hard to see how mental health legislation doesn't perpetrate this exclusion to normative rights at the national level. I think I don't need to go into more detail about that exclusion because I think Tina's made that point. Another point that struck me was some of the parallels in law of rendering other marginalised people groups as non-persons. Australia, where we're from, was founded on a legal myth along these lines. Terra nullius is a Latin expression deriving from Roman law meaning nobody's land. And the phrase was used in international law to describe a territory which has never been subject to the sovereignty of any state. This legal trickery placed hundreds of Aboriginal and Torres Strait Islander nations into the category, literally, of flora and fauna. And this continued in the 19th century, this sort of dehumanisation, when colonies passed laws to reduce the legal status of Indigenous people from British subjects to wards of the state. There's a useful concept from a social theorist called George Agamben who wrote about certain groups being placed in a permanent state of exception, sort of like when a country suspends laws in a state of emergency, where the normal rules simply don't apply. Again, it's hard to see how this doesn't continue to be the case in mental health law. But this is all quite despairing, and I think Cath's presentation shows us that amongst those marginalised groups there is a certain capacity to identify the hypocrisies and inconsistencies of a dominant culture and to offer alternatives. It's even interesting in the context of Indigenous people in New Zealand, which established a treaty between Maori people and settlers, that elements of customary law have been integrated into health law and policy. And there seems to be a far greater respect paid to relational autonomy and to families and kin and the social network or whānau of an individual who's in crisis. And in fact, Australian and New Zealand Indigenous communities typically view autonomy as a deeply relational matter. So there are synergies with the positive obligation in the CRPD to recognise supportive relationships where values of individual autonomy and collective decision-making work alongside each other. So in considering briefly how Indigenous communities respond to these issues, I should emphasise that there are very diverse communities and they're not simply an inverse of Western cultural values. But relational autonomy, as Rosie discussed briefly, has a strong tradition in Western philosophy too, particularly amongst feminist philosophers, and it's no surprise that it was embraced by disability activists and advocates. So my understanding of this project is to use the frame of legal capacity to describe the resources a person should have access to and the freedom they should enjoy, which is often stymied not simply by laws which mean that a person is lawfully restricted from making decisions, from exercising agency, from having liberty of the person, but more on a micro level as well, by which a person is denigrated, sometimes overtly, sometimes subtly. And the path to the type of treatment Cath described sort of sounds like it was made by public officials, nurses, bystanders, police, psychiatrists, who all took small steps of acceptance and acquiescence and rationalisation and political convenience and expedience, and above all, silence. So what kind of law could address this? I'll go into more detail in a written piece, but I think we've discussed it here today. A law that coerced the state into ensuring sanctuary for people in crisis. A law that placed an order on services to ensure support in the community, including via personal advocacy, family-based support, and a range of options. And laws that guaranteed women-only spaces for responding to distress, given so much harm is caused by men's violence. And laws that guaranteed the right to be free from coercive interference on an equal basis with others, all stuff we've talked about. And thinking about relational autonomy, a law that mandates working collaboratively, that ensures mechanisms for individuals to appoint their own support persons or rule out the involvement of others. And above all, it's clear to me that ensuring equal recognition before the law is more than legal change. In fact, it's more than equality, despite Article 12 being fundamentally about that. And I draw on this last quote from Anne Summers, and the language might be a little bit dated, or it's not dated, but it's from the 70s, and it sounds like it. And I changed this to sort of fit what we were talking about, but I regret it now, because I crossed out liberation and changed it with human rights, but I think it could probably be liberation and human rights. It says the struggle for and the attainment of human rights is all about altering the most fundamental tenets of our method of social organisation. It's about abolishing privilege and exploitation and concentrated power. So finally, I just thank Cath for being involved in this exploration and search for new social knowledge. So over to you.
I just wanted to finish, thanks for that. It's been a really great process of energy, I guess, and kind of swapping what we've read and what we've been thinking. But I did want to also just touch on the role of activism, because having sort of closed with this idea of, this letter that I written that was kind of it was a low point to sort of think that I'd actually got to that point of seeing myself as a kind of as constructed by this kind of being sick and not well and so on. I got introduced while I was actually an inpatient at what's called Royal Park, at the photograph of one of those institutions. A social worker, we sort of met randomly at a cafe. He had everything on site. You had your hairdresser, you had your cafe and all that kind of stuff. We met randomly, and she said, I think you might be interested in this project called the Understanding and Involvement Project. And from that moment, that sort of really led to work around being politicised and meeting people who were activists, and they were these amazing people who were just so switched on and smart and funny, and that was really the beginning of change for me. So the role of activism as well as the role of peer support, I think, are two things that I would put into that. Or access to kind of activism, rather than sort of in those days being told you shouldn't hang out with other people that are all sick and mad because it's bad for you. So yeah, I just wanted to put that in there around the search for alternatives and the kinds of things we ought to have access to. For me, activism and meeting up, particularly with the idea that to resist is actually okay, and to resist is something that is a collective effort. There was a board game developed by a colleague of mine called the Lemon Learning Board Game. The first where it's connected to the project, the Understanding and Involvement Project. The first where said shit happens, and this was a training tool for service users to train service providers. It was very creative and inventive, so it's the kind of stuff that was going on then. It was really exciting. And the little tokens were nuts in cashew or Brazil.
has from this discussion about consent and refusal to treatment to those deep thoughts around dignity and autonomy and justice. We have now our fourth pair. We have Lavanya Sheshashayi. She's a mental health activist, a self-advocate, a women activist, a writer, creative thinking, and a PhD on gender and mental health issues. And with her is going to be Matt Jefferson, a long advocate, one of the founding members of the European Network of Users and Survivors of Psychiatry, and also one of the leaders and board members of PO Scanning, a professional services with personal ombudsman for people with psychosocial disabilities. So I give the floor for you.
I just need to bring my laptop. Okay. Are you able to hear me? Yeah. So, let me introduce myself again. Of course, Alberto has already introduced me, but still I'd like to reintroduce myself. I am Dr. Lavanya Sheshashayi, and I'll come straight to my narrative. Now, the character name, this narrative is titled Reality Bites. So, the character named Aditi is me, Dr. Lavanya Sheshashayi. And Lekha is Dr. Lavanya's mother. This is just to make a few admissions before beginning my narrative. So Aditi was being detained at home and not being allowed to go to college to pursue a full-time basic graduate professional degree because she had just been labeled schizophrenic by the treating psychiatrist from the National Institute of Mental Health and Neurosciences in Bangalore, popularly known as the NIMHANS. And my dear reader, how did the dynamics of denial of full legal capacity play itself out in the clinical context, involving consent to treatment and professional psychiatric negativity? It was based on the Mental Health Act of 1987 that Aditi's family, that is her parents, were given full powers by the lady psychiatrist Dr. Padma Chandan in 1997-98 to confine her within the limits of their residence without sending her to college for a year. Aditi sat in the psychiatrist's chamber listening to the psychiatrist, who was explaining to her the law that gave Aditi's parents all the right to confine her at home without sending her to college for a year. Aditi could do nothing to protest against the fact that her parents were ruining her life by not sending her to college to study, all because Lekha had a mammoth ego that couldn't tolerate Aditi's questioning her about why she had privileged Aditi's brother Bobby but had given Aditi a horrendous upbringing just because Aditi happened to be a girl. And because Aditi looked like Lekha's sister-in-law whom Lekha hated. It was a time when she fought to save her face in familial circles, but was not allowed to. When she fought to be allowed to be able to go to college and complete her course, but was not allowed to. When she fought to silence the wagging tongues of people around her, but was not allowed to by her own menopause mad mother, who acted quite stupid, and more importantly her escapist father, who changed much later, but who had to so depend on his wife for sexual gratification that would be denied to him if he didn't support his wife. Society has oppressed us. We should have our own identity, which we're not having right now. If we were really allowed to have an identity, we would never be where we were. We therefore have to fight for our rights, fight a legal battle, launch a protest. Next, there are a lot of people like me. I must help them out too. Someday I will, cried Aditi, even as she wept bitterly in the doctor's chamber, in Dr. Padma Chandan's chamber. Dr. Chandan, however, didn't make the slightest sense out of this whole thing. Padma Chandan was refusing to offer Aditi the hope that she too could and would recover someday. Padma was merely consenting to confining Aditi within her parents' residence. Aditi hadn't been witness to the rising sun, to the hope that she could lead a very productive life. There was no hope for her in that medical chamber, a chamber reeking of forced psychiatry. Do I have to die without my dreams ever being achieved? Will I ever get married to a highly rich, educated, humane and handsome man? Will I never ever taste marital bliss, doctor? Aditi was sobbing helplessly. All the doctor did was to stare and ask her mother, Aditi's mother, does she cry like this very often? And Aditi's mother said yes, and I have no idea what I should do with her. Dr. Padma then said, I'll start her on an antidepressant product, 10 mg in the morning after breakfast, and 10 mg in the night before she sleeps. Let's see how this works on her. But doctor, if I have a friend whose shoulder I can lean upon, my difficulties will be gone. Will you be that friend? A friend for a lifetime. Will you love me and care for me? Now Dr. Padma Chandan truly felt Aditi was acting silly. She thought Aditi was expecting a bit too much out of her, Padma. Oh, you have such a nice mother, Aditi. I have to see hundreds of patients like you. I have research to conduct, conferences to attend, papers to present, theories and scientific stuff to catch up with, lectures to give, classes to take, and PhD students to guide. No, dear. All I can do for you is devote 10 minutes a week. I'll listen to you and medicate you. You can't really expect anything beyond that. Medicate, is that all? Yes, doctor, in short, I'm a pest. An unwelcome pest. A pest with a brain to be medicated and no feelings at all. It's okay, doctor, I'll resign myself to my fate. Aditi again wept bitterly. Now, Aditi, you are being paranoid, said the doctor, before she called the next patient in. This is clearly an assembly line of patients, a medical assembly line, thought Aditi, even as she sat weeping in the auto with her mother beside her, with nobody to comfort Aditi and help reinforce the idea that Aditi deserved and would have a wonderful future. A mother who had no idea how to care for a child who was a girl child who had gone sick and needed help and support, a mother who couldn't stand independence and growth in her children, especially her daughter, for that was what Lekha had been just then. A mother who had liked her timid son Bobby because he had clung to her apron strings. But if mother died, Aditi would never have anybody else to turn to either. Aditi had been made so dependent, helpless by her mother. Aditi again wept bitterly. Aditi's mother had been told by the doctor that what Aditi was in need of was a rest cure. The rest cure, however, did nothing to help Aditi rest. This was what she had been made to become just because she had trusted the medical system too much. Again, Aditi thought, how many generations of women like me will need to die before a change in this nasty system occurs? 4 or 5 generations of women? Should we all be allowed to die without any opportunity? Should we not study, marry or work or have a job? Should we not be allowed to fall in love? Can we never know what it is to get married and have children who will love us? I will and can do what the government has been unable to do all by itself. Someday I will rise up against this morbid system. I will, she screamed. And if everybody in the auto rickshaw, including the driver and her mother and the people on the passing street, stared at her, she didn't care. If I help 10 people with mental illness, they will help another 10 each. And this will lead to 100 so-called patients being helped. If each of these 100 people is helped, then totally 1,000 people will be helped. Then 1,000 can reach out to 10,000. 10,000 of people can help 1 crore other people. Within 10 or 20 years, all the women with mental illnesses will be reached out to. 5 generations of women with mental illness will not have to die alone. They will not have to die without rights. They will not be forsaken. I should have empathy and help the other women with mental illnesses. Nobody should have to go through what I'm going through. Owing to pressure from the extended family to take up a course in science, Aditi had formally taken up a speech and hearing basic degree course where there had been abundant politics from so-called Christians themselves, who treated her so badly that she was scared to attend college. Even this would have been overcome if she had been allowed to go to college and attend her classes and lessons. After the first time she failed in her exams, but her mother did not trust her to complete the course, nor did her doctor, nor did her father. And that had been their major undoing. They kept her home because she desperately wanted to study, but they did not want her to. And all this because she was a girl and because the system gave them the power to do so. And Dr. Padma Chandan had no clue of how she could inspire her patients to get well just then. She just listened to the others that othered Aditi. She had no clue regarding the patient's rights, or what her capabilities-informed approach was just then. And the auto stopped at Aditi's residence after 20 minutes of Lekha directing the auto while Aditi wept helplessly. She was all alone and in great pain. Many such patients had suffered similarly and presumably across the world just then, just because of a presumption of legal incapacity. The people with psychosocial disabilities in India had begun asking themselves who they really were. The system had traumatized themselves so much that they lacked a sense of identity. Hans George Gadamer's all too crucial question, how does the doctor take away the illness of the patient without taking away the personhood, had been very clearly left unaddressed. Even when patients were cured, whatever that meant as per doctors. They were not empowered, they were not healed. They did not always achieve personal recovery, they just existed. Clearly, the shift from the illness paradigm to the disability paradigm made the activists jump and ask several relevant questions because they wanted to support the disability paradigm. There were burning questions as to whether the Mental Health Act of 1987 was a disability rights law at all. And so now Aditi sits in her room where she's being confined. This seems like the very opposite of paradise, up and down, up and down. Aditi perambulates up and down her room, just like the peripatetic philosophers of Rome. She's certainly not one among the famous five. She has sorrows that are not yours, pains that are not yours, and no bitter sugar-coated memories that are in the refuge of the depraved, traumas that are not yours. The peripatetic perambulating philosophers of Rome couldn't have walked more slowly. She has troubles that are not yours, struggles that are not yours, and so up and down, back and forth she paces in her room. Forward 2, 3, 4, backward 1, 2, 3, 4, left 2, 3, 2, right 3, 2, 4. And sometimes it is right 1, 2, 3, 2, and yet at other times it is left 1, 3, 2, 4. On the wonderfully plus attractively tiled first floor room, at the top of her house, the house that had continued to be a house but never a home. Might have been a home at one point in time? Society ought to be kinder to the mentally disturbed, to the persons with schizophrenia she finds herself saying again and again. To the wall clock, to the pencil stand, to the pen stand, they are her friends. To the long steel glasses on her dusty table cluttered with all kinds of stuff that she might need. Old diaries that she might need. For reference, of course, she's a voracious diary writer. Things must be placed in their exact and right context. Who said what to whom and when. Separate the past from the present from the future, and the past from the future. No, she's not imagining things. She knows perfectly well for some time as to where she should draw the borderline separating imagination from reality. It scares her because she's still in her senses, not totally oblivious to things she sees around her, to things happening around her, but there are times when something else happens. She's back into her world where beginnings coincide with ends, collide with ends, curl up with ends, hazily, mistily, vaguely, and confusedly, where colors blend with one another so delicately that one can hardly make out the borders or boundaries or edges. A world where emotion unfalteringly thumbs her fruity nose at logic and makes her fumble and slips out of her arms greasily and smiles an anxious smile. It is a land of imprisonment and yet a land of freedom, paradoxically enough, and yet this is true. It is a land to which lots have escaped, and a land from which very few people have had the fortune to escape. And the few who do escape do so with great difficulty. She makes desperate attempts to feel secure in a tacitly insecure world. She does in fact watch TV programs and read all the artists' names, the characters, their real names, the names of the scriptwriters, directors, makeup artists, and cinematographers aloud. Literally everything that comes on screen, every letter and every number, which is her attempt at finding simplicity in a sordidly complex universe. I will be a writer one day, she finds herself telling her relatives when they question her. Her caregivers hadn't made the right decisions, the right choices. Was she to blame? Was she herself a motley, maddening montage of medley thoughts milling the mind in mindless fashion? To seek harmony in disharmony should be the sum and bonum of one's life. She finds herself telling herself, after all, her insecurity is an attempt to restore order to a world that is otherwise so disorderly. Creating crisscross patterns on the floor, walking in patterns on the floor, going forward and retracing one's steps backward. It is morning time to have one's bath. There are 2 stairs leading to the drawing room beneath. One of them is lucky and the other unlucky. It is the unlucky stair that should be climbed down at any rate. It is the lucky stair that should be climbed down at any rate. Lucky and unlucky, all of Aditi's memories are intact. Aditi washes herself with water for going down the lucky stair to the bathroom on the ground floor. After washing herself with hot steaming water and a soap, she covers herself with the long white towel she has and moves to the mirror to take a look at herself. She looks like a beauty model with the towel wrapped firmly around her body. She hopes to dry herself this way. She looks into the mirror again. Her cheeks have sunken. In fact, her once plump cheeks have hollows in them, reinforcing the beauty in her eyes. But of what avail? There's no man who would possessively and lovingly say she is all mine. No man with a decent education qualification. Of what avail is beauty that is never recognized? And this makes Aditi reinforce the convictions that real life has taught her. Beauty without the graduate degrees of no use. She has butterflies in her stomach even as she thinks of this. She has terrible sensations creeping up all over her hands and legs even as she says, I'm alone, there's nobody whom I can call my own. Previously she would have cried to think of this, but now she knows tears will not help. She resigns herself to her fate even as she goes to her room, to don the freshly washed and ironed cotton salwar kameez that she has washed and ironed without being aware of. It is only when she finds a pair of clothes washed, ironed, folded neatly, and placed on the bed that she realizes she must have done it while thinking of someone or something else. She has nobody to chide her lovingly, to coax or coddle her into eating her breakfast. That brings back bitter but sugar-coated memories of her mother. But what is going to become of me when Mama and Daddy are no longer there for me after they die? She whispers to herself, such a horrible thought. Yes, the creepy crawling sensations are beginning to come back. They're beginning to spread all over her body. She begins shivering and crying. It is a torture, but she hardly knows how to overcome this. Neither deep breathing exercises nor medication seems to be helping Aditi here. Her very existence becomes a torture to her. Can't somebody help her? Is there no solution at all? Must Aditi be doomed to lead this kind of a life? Every hour, every minute, and every second. Isn't it a shame on society? Isn't it a shame on society's part to be doing this to an individual? My Lord, why have you forsaken me? Says Aditi, even as he stares imploringly at the idol of the deity in her room, and the stone idol coldly stares back at her. And this is how it feels to be deprived of one's legal capacity, in the context of taking medication but not having other requisite forms of support. When the counseling and treatment by doctors doesn't reflect respect for human rights and agency of the person with psychosocial disability. When the doctor uses just the medical model without supplementing it with a capabilities-informed approach to deal with mental distress. Aditi felt a gnawing sense of insecurity at being confined to the home, not being allowed to go to college just because a psychiatrist asked her parents to keep her home. In vain did she tell herself that ikebana flower arrangement or some such activity would help. She dreaded the lady psychiatrist whose only questions to her parents when she was taken to the hospital in Bangalore had been, does she eat properly? Does she sleep properly? Does she take her regular dosages of medication 3 times a day? Does she get violent or agitated? Does she throw things at people, for instance? Without the thought being spared on why exactly she became violent or what made her violent. What made Aditi throw things? Social pathology was never corrected. The onus to change and recover always lay on the individual and never with the caregivers who made her who she was and what she was, and who were never assigned any responsibility or standard to change her behavior, to induce recovery or help induce recovery in Aditi. All they needed to be responsible for was to ensure the patient, as she was called then, took her medication. For even when the patient did make the decision to recover, she needed support. The much needed support was never given to her, at least not of the kind she needed, and thought was most conducive to her recovery. She did not feel good at all and began dreading the passing of each night into a new day. Time was passing. She hated clocks, for they reminded her that time was passing, and so she went to bed each night in a half-dazed state owing to the medication, dreading to even think, is this kind of a life the only thing I can hope for? Is it the only thing I have a human right to hope for? Am I not even entitled to dream of a better reality, hope for a better reality? Can't I be entitled to things the so-called normal others are entitled to? Am I just a body to be dealt with by psychiatry or medical science for that matter? Aditi was being gobbled up in her own world. Time was coming to an end. Her universe was ending. Her brain was exploding, for it could not take any more. At the familial realm, or at least in Aditi's family, being a wife and a mother, or being trained to be a wife and a good mother, were the only roles being conceptualized for women back then, and women who became hysterical or schizophrenic supposedly did so because they refused to accept these God-given, so-called God-given, God-ordained roles. Freud was supposedly outmoded in this psychiatric setup that treated Aditi, only supposedly. The dynamics of clinical operation, however, still reflected many of the Freudian ideas, only a matter of old wine and new bottles. There seemed to be a special privilege accorded to women who consented to be childbearing machines and sexual slaves to the men from the information technology pockets, who were the most prized and revered assets of Bangalore, the software engineers. And those men who were from a company called Infosys were certainly seen as the best picks. In the man-woman matching marital market, domestic prostitution, meaning the pretty woman would be treated like a prostitute by her own hubby, like a body to be used in nothing else, often on account of being prodded to do so by his mother, would soon follow the wedding and reveal itself in its ugliest avatar. Alas, and then the number of psychiatric admissions would increase, and there would be a gross shortage of psychiatric beds to accommodate those women who were socially unaccommodated victims of a conspiracy against women. A conspiracy supported by a greater number of women than men. by women themselves who were illicitly led to believe that marrying and having children, preferably sons, who in turn married and impregnated the other women and made them produce children, would be the hope of the Babylonian human race. This was the reality that made Aditi's mother confine her at home, because she thought letting her daughter continue with her professional education was a waste of money. Also, Aditi's mother thought the psychiatrist was the ultimate authority on Aditi. She assumed Padma Chandra knew more about Aditi than Aditi knew about herself. Aditi's burning questions therefore were, number one, what will happen to me after the death of my parents? Number two, with neither a basic educational degree, nor a job, nor a wedded partner, will I not then end up living on the streets? Aditi did, however, rebuild her life from the scratch and take back her full legal capacity. She was quick to realize that for her, education and education alone will help in empowerment. She charted out to use a survivor support system with her mother after bringing her mother onto her side and converting her to a supporter to help her study. She finished 3 years of her bachelor's degree, 2 years of her master's degree, and 5 years of her PhD in women's mental health after this happened. She then took up a very responsible job, and she was still waiting for her lover, Mr. Girish, a software engineer, to come and marry her. Consequently, he did meet her, speak to her, propose to her, and marry her after a long chase. The universe had finally responded to her cry that had seemed like a cry in the wilderness. Today, Aditi is a mental health specialist and self-advocate touring the world and sharing her story in model recovery, termed women's self-advocacy, with everybody who thinks they are in a situation they cannot get out of owing to a psychosocial disability. She's a passionate advocate of full legal capacity for the psychosocially challenged, since she knows only too well as to how one feels when one is stripped of one's full legal capacity on account of a psychosocial disability. She wants to inspire everyone, especially women, although men are not excluded, with the truth that no psychosocial disability is permanent, thanks to the richness, resilience, and capability of the human spirit to triumph over the worst adversities in life. And so the user needs to be treated as an expert in herself because she has subjective experience and experiential expertise that doctors do not have, medical doctors, I mean. She needs to be validated. We need to keep the user survivor at the center of the legal mental health discourse. Thank you for listening.
Okay, I should respond, although it's very little time. And I only want to highlight 3 points here very quickly. I suppose we say that this is a work in progress, so we have been working on this 2 days now. And it's also part of a much larger story, because Lavanya has sent me what is almost 2 full books, real books, I mean. So it's much more in the story that I know about. And it's a very good story. This is just a little bit of it. And so there's much more to learn from Lavanya. I just want to point out 3 things which I think is very good with the Lavanya story. First of all, if you have the whole story, the whole books, and also a little part already here, is that she really proves or shows very clearly that it is not a mental illness in that way, that it's not a biological illness at all. If you hear all her story, you can very well understand why this happened. There is a general background of the situation of women in India, but it's also not only about this on the general abstract level, because also get how it is influenced directly into Lavanya's life on a very concrete and detailed level. But there are also other things happening in her family, like her relation with her brother and other things. It's not part of what she was telling now, but really give you an understanding. This is not some irrational and not understandable illnesses. If you go into them, you can really understand why it happened. What you're more surprised of is that Lavanya had the strength to overcome it, because she had so much in her background to damage her, that you need that strength and that intelligence that Lavanya has to really overcome all this. That is a surprising thing. the other thing I want to say is that this is a good, her story is a good demonstration of what it means to lose the legal capacity. Because when you heard the whole story, and she did a little, in the end, she completed her story, she lost her legal capacity in many ways, but especially here that she was denied to continue her education at the university, and she was confined in her home. And in her story, she really tell you how bad that influenced her state of mind. It was not a help, it was the opposite. This passivity for a year made her much, much worse. And then she proved that she was right, because then she herself took back her legal capacity. Herself found a way back to the university and became well. So she proved that this denial of the legal capacity was wrong. And she was right, the doctors was wrong, and the parents at that time was wrong because they listened to the doctors. The psychiatrists were wrong. The last thing I want to say is that she also, in her story, described how important it was to replace substitute decision-making with supported decision-making. And in her story, it was actually Lavanya who forced her mother to change her attitude and behavior, and to change from doing substitute decision-making, which he did on behalf of psychiatrists, also other reasons. And you forced her to become a support instead of to support, carry out support decision-making. Lavanya didn't tell all of this in this story you just told, but she told me, or had written in other parts of the book, how she really convinced her mother to help her to study and to sit with Lavanya to sit in her mother's laps 8 hours every day, studying together. And it was very hard in the beginning because she had all this problem, all the medication just to follow the lines, to understand the lines. But she was supported by her mother, sitting there, and then she succeeded to get through her studies. And because in that process you became well. So that's it.
There was this kind of reparenting that happened, between me and my mother. So a bond was re-established, and after that I was secure enough to study on my own. There was this reparenting that happened with my mother. My mother reparented me, and there was this bond that was established, which enabled me to carry on with my studies. The first 3 years of my education, I sat on her lap 8 hours a day, as Matt pointed out. And I had to hold her and read my books. But she gave me that kind of support. She changed radically. And that is what brought about my transformation.
Thank you very much, Lavanya. Thank you very much, Matt, too, for putting together this story and help us to learn from them. So we are fashionably late, I think, but we may have 10 minutes for quick question and answers. We will keep having a space for question and answers, so let's start.